If it may please, Your Lordship. My Lord, the petitioner is challenging the notification, page number 60, Your Lordship. Annexure 6. This is the impugned notification, Your Lordship.
Page number
60.
yes.
60.
Yes.
My Lord, this notification, by way of this notification, Your Lordship, this notification was issued under Article 64, Your Lordship, and under Article 335, Your Lordship. By way of this notification, the state government has made 100% reservations with regard to Group C and a multitasking post, Your Lordship. And this is not permissible, Your Lordship. This may I read the relevant portion, Your Lordship, of this notification. Clause 1, Your Lordship. 100% post out of 80% stated above in Group C and
Page
multitasking.
number
60.
yes.
My Lord, this notification has been issued under Article 16(4), Your Lordship, and Article 335 of the Constitution, Your Lordship. By way of this notification, 100% reservation has been made in Group C and multitasking post, Your Lordship, in all departments in the district offices as well as in district administrations against direct recruitment quota, Your Lordship, which shall and this notification provides that the appointments shall be made amongst the APSC candidates of that particular concerned district, Your Lordship. And this notification is not permissible inasmuch that it violates Article 16 of the Constitution, Your Lordship. And that is why the petitioner is before Your Lordship challenging this notification.
But this power is exercised under
Article
clause
16.
4 of the Article 16.
Yes, Your Lordship. And that is why the petitioner is before Your Lordship, because clause 4 of 16, Article 16 does not provide empowers the state to make reservations on district on the basis of domicile, Your Lordship. May I take Your Lordship to Article 16(4) in that case?
Yes.
My Lord, Article 16, equality of opportunity in matters of public employment. Clause 1, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Clause 2, no citizen shall, on grounds only on religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible for or discriminated against in respect of any employment or office under the state. Nothing in this article, clause 3, Your Lordship, nothing in this article shall prevent Parliament from making any law prescribing in regard to a class or classes of employment or appointment to an office under the government of or any local or other authority within a state or union territory, any requirement as to residence within the state or union territory prior to such employment or appointment. Clause 4, this is where the notification has been issued under this clause, Your Lordship. Clause 4, nothing in this article shall prevent the state from making any provision for post in favor of any backward class or citizens in which, in the opinion of the state, is not adequately represented in the services under the state, Your Lordship. My Lord, Article empowers the Parliament, Your Lordship, to frame rules regarding it is only under clause 3 of the 16, Your Lordship, Article 16, that the Parliament is empowered to make rules, Your Lordship, and not the state. And however, in this case, Your Lordship, the state government, by an action of an executive fiat, Your Lordship, has framed this notification, which is not permissible. And this article specifically bars the state government to make reservations in case of appointments, Your Lordship, with regard to with regard to a domicile of a state, Your Lordship, of a district. And my lord, the Honorable Supreme Court has also held in several cases, Your Lordship, that the state cannot make reservations on the reservations on appointments for the purpose of offering employment to the concerned persons of a particular district, Your Lordship, on the basis of their domicile or residence, or by their place of birth, Your Lordship. And this is and the state government, however, has invoked this particular clause, Your Lordship, and this is not permissible.
Madam, notice may be issued for today, madam, because I believe there is no interim order. Notice may be issued.
But similar notifications are available in other states also.
I beg your pardon, Your Lordship.
Similar kind of provisions are made in some other states also.
My lord,
Reservation for the candidates of a particular district.
my lord, the Honorable Supreme Court has held that such kind of reservations on the basis of district, Your Lordship, be it a region or any lower district region of a particular.
Can you authority?
Yes, Your Lordship.
Can you show?
2002, volume 6. Five, 6, 2, Your Lordship.
Paragraph number?
Paragraph number 13, 14, 15, and 16, Your Lordship. 5, 6.
Paragraph number
13, Your Lordship.
13.
13. My lord, the Honorable Supreme Court has also held that when a reservation is made between a class of persons, Your Lordship, citizens, that reservation would be based on social and educational backwardness, Your Lordship, and not on religion, caste, creed, or place of birth, Your Lordship, place of birth, Your Lordship. I'm sorry. Paragraph 13. May I read, Your Lordship? Before proceeding further, we should steer clear of a misconception that surfaced in the course of arguments advanced on behalf of the state and some of the parties, based on the decisions which countenance geographical clarification for certain weighty reasons such as socio-economic backwardness of this area for the purpose of admissions to professional colleges. It has been suggested that residents within a district or rural areas of the district could be a valid basis for classification for the purpose of public employment as well. We have no doubt that such a sweeping argument, which has overtones of parochialism, is liable to be rejected on the plain terms of Article 16.2 and in the light of Article 16.3. An argument of this nature flies in the face of the preemptory language of Article 16.2 and runs counter to our constitutional ethos, founded on unity and integrity of the nation. Attempts to prefer candidates of a local area in the state were nipped in the bud by this court since long past. We would like to reiterate that residence by itself, be it within a state, region, district, or lesser area within a region, cannot be a ground to accord preferential treatment or reservation, save as provided in Article 16.3. It is not possible to compartmentalize the state into districts with a view to offer employment to the residents of the district on a preferential basis. At this juncture, it is appropriate to undertake brief analysis of Article 16. Article 16 has been
This clause 4 has not been discussed in this.
My lord,
Clause 4.
it has been, my lord, may come to next paragraph. My lord, if your lordship takes clause 4 of Article 16, your lordship, the state can make reservations of appointments with regard to those class of citizens, your lordship, who are backward, your lordship, in the opinion of the state. And to determine the backwardness, your lordship, that backwardness would be on the basis of social and economic decisions, factors, your lordship, and not on the basis of a place of domicile, a birth, caste, creed, or gender, your lordship. And that backwardness has to be determined only on the basis of social and economic factors, your lordship. That is what the Honorable Supreme Court has held in this judgment, your lordship.
Well, let notice go then. Discuss it.
Yes, madam. I will appear for 1, 2, and 3.
Pardon is the Tamok, Lord Council for the Petitioner, and Mr. Andropan, Lord Council for the Petitioner Z to the respondent number 1, 2, and 3.
Yes.
And Mr. Carto,
Madam, I am for respondent number 4.
respondent number 4. Legality and validity of the notification number AR47 stroke 10 dated 2/6/2011 issued by the Chief Secretary to the Government of Arunachal Pradesh is challenged in this petition under Article 226 of the Constitution of India. Peruse the petition and the documents lesson record and also peruse the notification dated 2nd June 2011. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued since all the respondents are represented by their standing counsel. However, extra requisite copy of the petition will be furnished to them during the course of the day. It's the matter of 4 weeks.
Much obligation.
It was 7 and 8.